Ladies and gentlemen, we'll call to order the meeting of the Rockingham County Board of Elections for the purpose of hearing protests from Philip E. Berger, Senate District 26. For the purposes of this hearing today, we'll be looking to see if there's probable cause to move this into an evidentiary hearing based solely on the application. We will not be taking oral arguments or presenting evidence in this meeting. It'll be based on simply on the protest forms that were sent to this office. So having said that, we will do those. We'll have Ms. Seamster read those, and then we will discuss each one individually. We will cast our vote based on all three collectively. Ms. Seamster.
Okay, the first one was provided by Philip E. Berger by legal counsel, and it says this protest concerns 3 unaffiliated voters in Rockingham County: Russell Lee Collins, John Philip Murphy, and Michael Aaron Baker, who appeared to vote in the March 2026 primary, initially selected a Democratic ballot, and then later changed their minds and requested a Republican ballot. Each voter was permitted to cast a provisional Republican ballot, and those votes were counted in the Republican primary. The official authorization to vote, ATV, records reflect that each of the 3 voters is registered as unaffiliated and at check-in selected a Democratic ballot. The election official issued each voter an ATV reflecting the Democratic ballot selection. After that point, each voter requested a Republican ballot instead. Election officials called the Democratic ATV and issued a voter a provisional Republican ballot, which the voter cast and which was later counted. See Exhibit A, ATV records and provisional records for each voter. The canceled Democratic ATVs and the associated provisional Republican records establish that. For each of the 3 voters, the voter's official ballot selection for the election transaction was Democratic, but the voter ultimately cast and had counted a Republican ballot via the provisional process.
Ms. Seamster, I believe that prior to the meeting, we talked about how much of this we would read for the board's purposes, but I do believe the legal argument is going to be necessary for the board to determine why the campaign thinks that, you know, this is a proper protest. Can you read the legal argument?
Oh, yes, I can. I'm sorry.
You can stop at number 7 where it lists off the individuals you may want to call as witnesses.
Unaffiliated voters are entitled to participate in a party primary only by selecting one party's ballot for that election. NCGS 163-119 and NCGS 163-166.7A. That selection is reflected in the voter's authorization to vote and governs which party primary the voter may participate in for that election transaction. Here, the official ATV records show that each voter selected a Democratic ballot and executed an ATV reflecting that choice. See Exhibit A. Election officials then canceled those Democratic ATVs and issued provisional Republican ballots, which were counted in Republican primary contests. See Exhibit A. This procedure effectively allowed the voters to cast votes in Republican primary contest, notwithstanding their initial Democratic ballot selection documented in the official ATV. Provisional voting exists as a fail-safe when eligibility cannot be confirmed at the voting site, not as a mechanism to allow a voter to switch party primaries after executing an ATV and receiving a ballot. See NCGS 163-166.11. The act of voting rule further underscores why party ballot switching must be handled through controlled procedures rather than ad hoc conversation to a provisional ballot. 08 NCAC 10B.0104. Allowing these votes to count in a Republican primary undermines the integrity of the party ballot selection process and results in illegal votes being counted in Republican primary contests. Accordingly, the board should sustain this protest in order that the 3 provisional Republican ballots issued under these circumstances be disapproved and removed from the Republican primary totals for any affected contest, including the SD 26 Republican primary, if applicable. The board should further require preservation and production of the canceled Democratic ATVs and related records for these voters so that the official record reflects the voters' initial party ballot selections and the manner in which the provisional Republican ballots were issued and counted. NCGS 163-119, NCGS 163-166.7 in parentheses A, NCGS 163-166.11, and 08 NCAC 10B.0104.
Seems there would be one correction in the above paragraph. I believe that it says allowing these votes to count in the Republican primary undermines the integrity of the party. I'm sorry, one more sentence up. The active voting rule further underscores why party ballot switching must be handled through controlled procedures rather than ad hoc conversion to a provisional ballot. And under item number 9, the relief sought from this protest, Ms. Seamster,
is I am uncertain whether the outcome of this contest will change, but due to other pending protests and recounts, this vote may be determinative of the outcome. Therefore, this protest is contingent on the votes at issue becoming determinative based on the outcome of the recount and other protests filed.
And number 10, what relief does the campaign seek?
The Rockingham BOE should receive and discount the ballots of these voters. Can I make a comment on that?
Sure.
There's no way to retrieve which one is which. The only thing on provisional ballots is provisional or a P. It is not voter specific. I just want to put it on the record.
Okay. And that will most likely be something for the state board to determine at any rate. And then we have, ladies and gentlemen, with this protester certification. Ms. Seamster, I'm assuming that this protest was filed in a timely manner according to law?
This one was. Yes, sir.
Okay, ladies and gentlemen, what's the discussion concerning this protest application?
Chair, I do have one question.
Yes, ma'am.
The email, contact council doesn't have an email here, and underneath it notes, you will be deemed to consent to service at all of the above addresses, including email, unless you attach an addendum indicating otherwise. I'm just asking,
And what,
should there be?
what page is that on? I'm sorry,
It's
ma'am.
on one.
Page 1.
It's one. Protester email. It says contact council.
So those emails are included in the council of record addendums.
I'm just saying.
Brian, can you hear me? Brian?
I can hear you.
Okay, so ladies and gentlemen, our board attorney, Brian Farrell, is on the phone, so I'm going to put the mic down here so you can hear the conversation. On the front of the protesting form, Ms. Wright has indicated that she sees something there that concerns her. This name, Philip Berger, underneath it says email contact counsel, phone contact counsel. Is that something that should be considered in reviewing this application for probable cause?
I think it's standard to include counsel as contact.
And so that contact information for the counsel, I think appears,
It's included on the counsel of record addendum.
that's correct. I was just getting to it. Okay. All right. That is the counsel, that's page 7 of 7, Ms. Wright.
Right.
So does that satisfy your question concerning that?
No.
No, okay. Then we'll have to move on because I don't know of any other way to satisfy that other than, Brian, you don't feel that makes this inherently, can't think of the right word, but inherently unable to accept it.
I do not think it's defective given the
That's what I was
contact
looking-
information provided.
Thank you. All right,
So I'll accept that from counsel.
thank you. Is there any other questions concerning this?
Yes, I have a couple of questions for the attorney. The first one is under the legal argument where it states the NCGS 163-166.7A. I pulled that up and I read that, and I didn't read what this is purporting. In other words, there's one of the options that's listed in there that you can spoil a ballot. So I'm not sure that I understand the legal argument of saying that because they were given the wrong ballot, they were stuck with it, when there seems to be in that law something that gives them the chance to undo that.
Yes, sir. Mr. White, I would suggest to you that that would be evidentiary and that would have no basis on trying to determine probable cause today. I think that the probable cause has to be decided off the face of the application.
So that's my question for the attorney, though, because this is the legal basis of this going forward at all. And so that's my question, is whether there is the legal basis for this complaint at all
So
from that.
there again, I'm going to say that I'm sorry, I don't believe that this is the proper venue to ask.
I would like an
That's it.
answer from the attorney, please.
Yes, sir. I'm not going to allow that. Brian, do you have any?
Allow me to get an answer from our attorney?
We're not allowing the attorneys to argue.
I'm not asking for their attorneys, I'm asking for our attorney.
Brian, did you hear the statement by Mr. White?
Yes, I did hear the question, and he was referencing the particular statute cited in the legal argument. And what I understand is that for these three, right, these unaffiliated ballot switchers, the question is, whether that they were entitled to vote after the initial selection of the ballot, right? I mean, that's the fundamental question.
It is.
Yes.
Right. And so it does seem to me that whether or not they completed or were, finished with their act of voting is going to be a relevant question to whether or not this protest should ultimately be sustained. And I don't think you can know those facts, and they won't be fully developed until the evidentiary hearing.
Okay. My next question for our attorney is on number 7, where it lists the potential witnesses. It ends by saying the election officials who assisted each voter. My concern or my question on that is that when we get over to number 14, where it lists the affected parties who have been alerted to this issue, it seems that those election officials are the ones who are being accused of the wrongdoing, and they don't seem to have been notified of this complaint. Is that an issue?
I appreciate the question. I don't think I read it quite the same way. I think that I I read them to be potential witnesses to the facts of what happened with these particular voters on the day of voting. So I don't think that they are affected parties. I think the affected party is, of course, the other candidate listed there on box 14. I believe that the official who assisted those voters, that they would be witnesses to the facts of the voting.
Okay. I'm looking, okay, here it is. So my last question on this one that I know of for now is in the legal argument, it says on the first line of the second paragraph, executed ATVs. When I go to John Philip Murphy, it looks like there was a Post-it note added in that says incorrect ballot, but there is no signature on this, so I'm not sure that this is an executed ATV when no one signed it, and Mr. Murphy, certainly there's no evidence that he agreed to accept this ballot.
Signed it right there.
Hang on just a minute, Brian.
That is the provisional ballot, not the ATV.
That's what he voted on, the provision.
Right. This says that there was an executed ATV, and what I'm seeing, there was not.
Now, where are you reading that it said it was an executed?
Okay, Brian, were you able to hear the question?
Yeah, I did hear the question, and I think the factual allegations in the protest itself, are what they are for your purposes today. Certainly, if you decide to move to an evidentiary hearing, the actual documents, right, to be introduced at the hearing may answer some of that potential discrepancy there. But I understand what you're saying. I'm looking at that ballot too. But the best records of all of that, of course, are the records that the Board of Elections has and could be produced in the evidentiary hearing.
Okay, thank you.
All right. Are there any more questions? Hearing none, we will move on to the second protest.
Okay, the second, the contact is Philip E. Berger by legal counsel. The factual basis is this protest concerns, oh, sorry, wrong one. All right, Courtney Charmaine Dillard is a long-time Rockingham County voter who timely submitted an update to her voter registration to change her party affiliation from Democrat to unaffiliated on February 6, 2026, before the registration deadline for the March 3, 2026 primary election. Exhibit A, updated registration form. Ms. Dillard completed the party change form with assistance from Trevor Hale. Dillard completed the form in Hale's presence and left it in his possession. See Exhibits B and C. On February 6, 2026, Diane Parnell, the chair of the Rockingham County Republican Party, requested that Maxine Dale Rosenberg Warren hand-delivered Ms. Dillard's party affiliation change form for the March 3, 2026 primary election. Ms. Rosenberg picked up Ms. Dillard's completed form from Mr. Hale and hand-delivered Ms. Dillard's completed change of party form to the Rockingham BOE. Specifically, Rosenberg handed the form to a staff member, Tina Massey. Additionally, Rosenberg asked staff member Polly Makins whether Ms. Dillard's party change would be reflected in the Board of Elections records as received before the deadline, and thus effective for the 2026 primary election. Polly Makins assured Ms. Rosenberg that it would be see Exhibit D. Ms. Dillard then presented to vote during early voting on February 27, 2026. Ms. Dillard intended to vote a Republican ballot and attempted to do so. Specifically, Ms. Dillard requested a Republican ballot from election officials. However, election officials informed Ms. Dillard that her party affiliation had not changed and that she was required to vote as a Democrat. Election officials did not provide Ms. Dillard with a Republican ballot. Rather, Ms. Dillard was forced to vote a Democrat ballot against Ms. Dillard's expressed wishes. Additionally, Ms. Dillard was not offered a provisional Republican ballot to preserve her claimed party status pending verification, and she was thereby deprived of the opportunity to cast the ballot she sought to cast for the Republican primary. As of March 17, 2026, Ms. Dillard's voter registration record still reflects a Democratic affiliation, confirming that her timely party change submission was not processed as represented. See Exhibit E.
And the legal argument, please.
Timely submitted a party affiliation change from Democrat to unaffiliated on February 6, 2026, the registration deadline for the March 3, 2026 primary. The Rockingham BOE had a duty to accept and process the registration update, NCGS 163-82.1B-826 in parentheses A. Ms. Dillard then presented to vote during early voting on February 27, 2026, and sought to vote a Republican ballot. As an unaffiliated voter, she was entitled to choose the party primary ballot she wished to vote. NCGS 163-119-166.7 in parentheses A. Instead, she was told she had to vote as a Democrat. Even if election officials believed on February 27, 2026, that Ms. Dillard's registration record still reflected DEM, the law required that she be offered a provisional ballot to preserve her claimed status and requested ballot choice pending verification. NCGS 163-166.11. State board rules likewise treat provisional voting as a fail-safe mechanism and require election officials to inform voters of the option to vote provisionally and to ensure a voter receives the appropriate assistance when eligibility or ballot-style questions arise. 08 NCAC 10B.0103 in parentheses D, 08 NCAC 10B.0101 in parentheses G in parentheses 10, forcing Ms. Dillard to vote a Democratic ballot rather than offering a provisional Republican ballot was inconsistent with these requirements and deprived a known voter of the ability to cast the ballot she was entitled to cast as an unaffiliated voter. This irregularity involves a known voter and a ballot type error that can be remedied in a targeted, non-speculative way. The state board has general supervision over elections and authority to address failures by county boards to comply with election law duties. NCGS 163-22 in parentheses A and in parentheses C. In addition, the state board has authority to take action necessary to ensure the election is determined without irregularities that may have changed the result, including authorizing recasting procedures where a known voter or known group of voters was given an incorrect ballot. NCGS 163-182.12. Accordingly, to ensure Ms. Dillard's vote is counted once correctly and not twice, the appropriate relief is as follows. Number one, the county board should identify Ms. Dillard's February 27th, 2026 early vote ballot and discount it from the total votes for the affected contest. And two, the state board should authorize and the Rockingham BOE should implement a procedure allowing Ms. Dillard to recast a ballot consistent with her lawful ballot choice as an unaffiliated voter, with the recast vote added to the returns and included in the canvass under state board-approved procedures.
And so would you read number 9, the relief, and number 10, please?
The relief is due to other pending protest and recounts. This vote may be determinative of the outcome. Therefore, this protest is contingent on the votes at issue becoming determinative based on the outcome of the recount and other protests filed.
And then number 10, it goes to the relief salt.
2 marks there. The first one is to correct the vote count. The second is the Rockingham BOE should retrieve and discount the Democrat ballot Ms. Dillard was forced to vote, and the State Board of Elections should instruct the Rockingham BOE to allow Ms. Dillard to cast a ballot of her choosing pursuant to NCGS 163-182.12.
Okay. And again, Ms. Sempster, this protest was filed in a timely manner consistent with the North Carolina General Statutes?
It was.
And as far as you can tell, it is complete on its face with the requirements of the law? Okay. Ladies and gentlemen, do we have any questions concerning this protest? Hearing none, let's move to the third and final protest.
The person filing this protest is Philip E. Berger by legal counsel. Factual basis, Kara Millsaps Price, a Rockingham County resident domiciled within Senate District 26, was eligible to vote in the March 2026 primary election to select Republican candidates for the upcoming 2026 general election. Ms. Price was, however, forced to vote a provisional ballot, and her vote was not counted. Ms. Price and her husband, James Brian Price, are both registered Republicans and have been consistent voters in North Carolina for the last 24 years. See Exhibits A and B, voter histories. They voted in Forsyth County from 2002, 2008, and then in Guilford County from 2010 to 2024. In late 2024, the couple moved from Summerfield, Guilford County, to a new home in Madison, Rockingham County. See Exhibits C and D, declarations of Kara Millsaps Price and James Brian Price, respectively. In late 2024, the couple completed North Carolina voter registration applications to change their voter registration from Guilford County to Rockingham County. They mailed the applications in the same envelope. In August 2025, Ms. Price made an in-person visit to the DMV to renew her driver's license and update her address to her new Rockingham County residence. At the DMV, she was asked whether she would like to update her voter registration. Despite knowing she had earlier mailed her voter registration form, she instructed the DMV staff to proceed with updating her voter registration as well. The couple presented to vote in Rockingham County on primary election day, March 3rd, 2026. Mr. Price's registration change had been properly processed, and he was allowed to vote without incident. However, unexpectedly, Ms. Price was informed that she was not registered in Rockingham County and therefore could not vote there. She was told she was registered to vote in Guilford County. Ms. Price even presented her driver's license that showed her Rockingham County address. Knowing she had attempted twice to update her registration, once via mail, once in person at the DMV, and believing this must be a mistake as she was a resident of Rockingham County, Ms. Price voted a provisional ballot in Rockingham County. The Rockingham BOE was unable to locate any record of Ms. Price's registration update, either the mailed application or the DMV submission. When Ms. Price's provisional ballot came before the BOE for adjudication, the BOE disapproved her provisional ballot. Ms. Price was otherwise qualified to vote in Rockingham County as of the March 3rd, 2026 primary. She is a U.S. citizen over 18, not disqualified by, was not any failure of eligibility on her part or a failure of diligence, but an apparent administrative error by government officials in the processing of her registration update, either through the DMV transaction, the county or state board's receipt processing of the mailed application, or both, despite her diligent, redundant efforts to update her registrations. Thus, due to no fault of her own and despite her diligent efforts, Ms. Price was unable to participate in the primary election for Senate District 26.
Okay, and the legal argument.
Ms. Price's provisional ballot should be approved and counted because she was a qualified voter domiciled in the Rockingham County and Senate District 26 at the time of the March 3rd, 2026 primary, and the only reason she was not issued a regular ballot was an administrative failure to process her timely registration update. The North Carolina Constitution guarantees the right to vote to qualified citizens. NC Constitution Art 6, 1?
Article 6, Section 1.
All right, Article 6, Section 1. The Constitution also provides that a person who has resided in the precinct or election district for 30 days preceding the election is entitled to vote. North Carolina Constitution, Article 6, Section 2, in parentheses 1, the election code likewise requires 30 days residence and provides the qualified electors are eligible to vote, NCGS 163-55, in parentheses A. Residence is determined by domicile and shall be broadly construed to provide all persons with the opportunity to register and to vote, NCGS 163-57, in parentheses 1. North Carolina law also places an affirmative duty on county boards to register qualified voters who apply and to accept voter registration applications submitted through authorized methods and agencies, including the DMV, NCGS 163-82.1, in parentheses B, -82.3, in parentheses C. Ms. Price took the steps that statutes contemplate to update her registration after moving counties, including submitting a voter registration application by mail, NCGS 163-82.6, in parentheses A. She also attempted to update her registration through a DMV transaction, as provided for in NCGS 163-82.19, in parentheses A. Critically, the General Assembly has directed the DMV voter registration applications accepted by the deadline shall be treated as timely made, and that no person who completes an application at the driver's license office shall be denied the vote in that election for failure to apply earlier than that deadline. NCGS 163-82.19, in parentheses A. Ms. Price is an otherwise qualified voter who was required to vote provisionally solely because her timely registration update was not processed through no fault of her own. The Rockingham BOE should not refuse her the franchise due to an administrative error. Instead, the BOE should approve and count her provisional ballot.
And if you would read the relief sought under Section 9 and 10.
It says, due to other pending protests, this vote may be determinative of the outcome. Therefore, this protest is contingent on the votes at issue becoming determinative based on the outcome of the recount and other protest filed. And the relief, first one is to correct the vote count, and the second is to retrieve the 2026 primary provisional ballot of Kara Millsaps Price, count her ballot, and add it to the vote totals.
Okay, ladies and gentlemen, that concludes the third protest. Do we have any questions concerning this one?
I have a question for our attorney, but it's really concerning all three, so I'd rather wait and see if there's any other questions specifically about this one first.
Are there any other questions concerning this protest? Hearing none, you want to go ahead and ask your question?
Yes. So this is for our attorney. On number 9 of all three of these, it says, due to the other pending protests, this vote may be determinative of the outcome. Therefore, this protest is contingent on the votes at issue becoming determinative based on the outcome of the recount and other protests filed. Recounts are now done. They did not change the numbers. We are looking at a total of 5 possible votes here. I watched the live stream of the Guilford County meeting, the other part of this district, and they're looking at 7 votes. And with a 23-vote difference right now, I question whether there is something determinative here that would change anything and whether that qualifies any of these to go forward.
I appreciate that question, and what I'll say is, this is a multi-county election, and so, I don't know what's going to happen in another county. You have the protests that are before you, and it's just simply not clear, in my view, if they'll ultimately be outcome determinative or not because of the protests not only in Rockingham, but also in Guilford. And at the conclusion of that, I'd be interested, did they decide to move the protest forward?
I believe I heard them say that they were unsure of what the final answer was of the recount in Rockingham County, so they did move it forward.
Right. Yep. And so what I would say is, at this stage of the proceeding, because there are other live protests, that's a tough question to answer, is whether or not it will be outcome determinative. I don't know that you know that yet, but I certainly understand the argument that the total protested votes, in both counties fall short of the 23-vote differential. However, because you don't know, I think it's difficult to make a judgment on that, and that's something the board can wrestle with.
Okay.
Is there any more questions concerning these applications before we move on to discussions about our vote? So hearing none, let me just say that during this discussion, if the board members would direct their comments to the chair, if we need our attorney, of course, he is available to us. But I would like to reemphasize to you that the purposes of this meeting is determined if there's probable cause based on the facts and the legal arguments set forth in these protests to move this to an evidentiary hearing. This is not a hearing in which we decide whether these are true or baseless or anything else. It's just that we decide the probable cause, and probable cause is defined as a legal standard that uses reasonable grounds based on objective facts and evidence to believe that, an error has been committed or a violation of election law has been committed. The definition, it is a fair probability or a substantial chance is what probable cause is. It's more than a gut feeling, but it's less than a standard it is or it is not. So it's just a reasonable effort to make sure that there's not a frivolous protest that we move forward, but that there is some belief in the fact that some of this could actually be true and have affected or affect going forward through this entire process, the election at hand. So having said that, what conversation do we have on this prior to taking a vote as to whether we allow this to go to an evidentiary hearing or not?
Mr. Chair, my first question is, does it have to be a unanimous vote?
I don't believe so. Brian, could you answer that?
No, your board is majority rule.
Okay. Is there any more questions?
Is the plan to vote on these three separately or collectively?
Collectively.
I would ask for separate if you would accept that.
I will accept that. Any other questions? Brian, I do have one question. As chair, do I have the ability to make motions in this proceedings?
Yes.
Okay. Okay, so ladies and gentlemen, let's go back to the first one that we took up. This was the protest concerning Ronald Lee Collins, John Philip Murphy, and Michael Aaron Baker. Do I have a motion to accept or reject this for an evidentiary hearing?
Mr. Chair,
Dr. Jones.
in light of what we have heard and in the light of our attorney's comments as well, I would move that we do recommend an evidentiary hearing.
I have a motion to recommend an evidentiary hearing. Do I have a second?
Second.
Here in a second, is there any discussion on this before we vote? Hearing none, all in favor say aye. Aye. All opposed, like sign.
Aye.
Motion carries. The next protest that we will take up is Ms. Price, Kara Millsaps Price. Do I have a motion?
Mr. Chair, I make a motion that we accept the information provided and that it be forwarded for an evidentiary hearing.
I have a motion for an evidentiary hearing in the matter of Ms. Price. Do I have a second?
Second.
Having a motion and a second, is there any further discussion? Hearing none, all in favor say aye. Aye. All opposed, a like sign. Motion carries. The third and final protest would be Charmaine Dillard. Do I have a motion on Ms. Dillard?
Mr. Chair,
Dr. Jones.
I would move that we recommend an evidentiary hearing.
I have a motion. Do I have a second?
Second.
I have a motion and a second. Is there any further discussion? Hearing none, all those in favor say aye. Aye. All those opposed, like sign.
No.
Motion carries. Ms. Seamster, is there any further business before this board today?
Yes, we need to actually set that hearing date. We have 7 business days, and I will need 5 business days to actually send out notices to the affected parties.
So I believe that would be Friday, Monday, Tuesday, Wednesday, Thursday, so the earliest we could have it would be next Friday. Is that correct?
That is correct.
And that,
What's the date?
27th is next Friday.
and since Saturday and Sunday doesn't count as business days, it could carry over to Monday if that suited the board better. Is that correct?
Yes.
So,
Mr. Chair, if I can say, and I don't know the dates, but I did watch the live stream in Guilford County, and I know the attorneys from both sides made some agreements on that because one of the attorneys is going on a trip, and I believe he said he leaves on the 30th.
So I personally would entertain some input from the attorneys on this. We certainly don't want to hinder you from being here.
Thank you, Mr. Chair, members of the board. Paul Cox from Pointers Pool Law Firm on behalf of Sam Page. We would be happy to have this evidentiary hearing next Friday, and we'd be ready to go. Barring that, I'm not available as the lead counsel for Mr. Page the following week, so the next day I would be available would be the 6th, although Guilford scheduled their hearing for the 6th, so we would ask that it be not the same day.
Okay? So, counsel for Mr. Berger.
Mr. Chairman and members of the board, my name is Trevor Stanley. I'm an attorney at Baker and Hostetler. We would consent to moving the hearing to April 7th or sometime after the 6th, so it doesn't conflict with the Guilford hearing.
Okay, so what about, let's see, I believe that next Friday is what date?
The 27th.
So either of you gentlemen, are you available on that day?
Yes.
I'm actually, oh, okay.
All right, so I have a conflict here. So
We have a conflict on the 7th.
on the 7th. Okay, so on the 27th, we don't have do we have a conflict amongst the board members? No. Okay. So what about you gentlemen?
I do have a conflict on that date, on the 27th, but Mr. Thomas said that he is available on that date if the board would so like to move forward on that date.
Now, let me ask you this, not prying into your business, but I'm going to ask you, is your conflict for the entire day?
So I also have a trip with my family out to California.
understand.
I've gotten as far away from North Carolina as I can possibly get, and I apologize for that.
We would like to, too, as soon as you lawyers finish up. But
Well, to be clear, I love North Carolina, so it's not, there's no,
I understand. All right, so.
my wife is from here, so.
If your wife says you're going, you're going. So I got you. I'm married, too.
Mr. Chairman,
Yes.
in that vein, I'll be in New York on the 7th.
It's not the 27th.
The 27th is what we're looking at, Brian.
Okay, all right, good. I misunderstood.
Although we could do it on the 7th and save you that trip.
No, the 27th is within our window, and who knows if I'll go anyway in
Right.
these days, but the 27th is fine.
Okay, all right. So, Mr. Thomas, are you good with this on the 27th? Okay. All right, so I have a suggestion of 2 p.m. Does that interfere with anybody's plan? I'm trying to be as cooperative as I can, okay? So I have both attorneys say they can be here. Ms. Wright, does that work for you? How about the rest of the board?
Yes.
Okay. I guess it doesn't matter whether I can do it or not, but I can be here. I'm just kidding. I understood I was correct in that. Okay, so we will have this evidentiary hearing on Friday, the 27th at 2 p.m. Gentlemen, we will notify you. We'll have to notify the public anyway, but we'll have to make sure that there's nothing going on in this particular, in the commissioner's chambers for that day. So we'll get on that as soon as we leave here. All right, now, Ms. Seamster, is there any further business for this board?
That's it.
Yes, sir.
It's a procedural kind of technical matter in terms of preparing for the evidentiary hearing. The administrative code on election protests allow a party to request subpoenas for witnesses to come testify.
Absolutely.
We'll plan to send those via Paula to the board, but my question really is whether we need to subpoena the board's staff, because the board staff would have evidence about the processing of registrations and that sort of thing. We would like to get testimony from the board staff, and we won't send a subpoena if we don't have to. So the question is, do you need a subpoena for the staff?
Well, I think, Brian, you can correct me if I'm wrong. I think that I would probably like to have a subpoena for the staff because that puts them on notice that they've got to be here. So we're not trying to work around schedules to get this done, because I suspect there will be numerous witnesses requested between the two campaigns.
Fair enough. I'm sure Paula would arrive anyway, but we'll do
Paula's
that.
going to be here. That I can, yes, ma'am.
Is that okay with you?
That's fine, Mr. Chair, but, we can certainly accept
Subpoena
those
your
subpoenas.
staff.
Paula can accept those on behalf of the board and, accommodate the staff to be there.
Okay, all right. And so that was going to be one of my questions. I'm sorry that I don't know this. I'm assuming in this proceedings, you have subpoena power, or does that all need to go through the chair?
It goes to the board, either the chair or two members of the
members.
board can issue
So-
a subpoena upon request.
All right, so Mr. Thomas, if you have any subpoenas that you'd like issued, would you forward them to Paula, and I'll make sure that Brian gets those and gets them out in a timely fashion?
Absolutely, sir.
Thank you. Is there any further work for this board?
If you do two, one Republican, one Democrat.
We don't have to, so I can do them as a chair, and I don't have to have two board members. So I'll just approve them, and we'll do it that way. All right, so is there anything else? All right,
I just want to say, because I think everybody's in agreement, but I saw some concern about subpoenaing the board staff, and I just want to say that I agree that I think it's best to dot every I and cross every T and
Absolutely.
subpoena people who theoretically don't need to be, but I would rather it be on the record.
absolutely. Thank you. All right, do I have a motion to adjourn?
So moved.
Second. All in favor, say aye. Aye. Thank you. Meeting stands adjourned.